Disturbances and illegal activity. Servers and sellers, as well as licensees, have a responsibility to prevent customers and other employees from engaging in illegal activity in or near the premises. Example of things that might occur include illegal gambling, illegal drug use or sales, trafficking in stolen goods, intoxication, or prostitution. You must take actions that are reasonably necessary to terminate the disturbance. If at any time the customers are not responding to your actions, or you believe that you, your customers, your coworkers, or others are in physical danger, place a call to local law enforcement and follow their instructions. Disorderly conduct by persons on a licensed premises, either off-sale or on-sale, is strictly prohibited. Disorderly conduct could be engaged in fighting or seriously disruptive behavior, making unreasonable noise, using abusive or offensive language to try and provoke someone, making a commotion to disrupt business, refusing to leave an area as directed by officials, for instance, the scene of a fire or an emergency, recklessly handling or displaying a firearm or any object that could be used as a weapon. In essence, if a person's action is going to cause a fight, they have to go. If someone is being disorderly, you simply cannot sell or serve them a spirituous beverage. In fact, they have 30 minutes to leave the premises. That also means they cannot hang out in the parking lot. Alcohol will fuel the fire, and the situation can escalate to the point of no return, which can lead to an act of violence. At any time you feel that the safety of your fellow employees or customers are being threatened with physical harm, you simply call the police. The DLLC defines an act of violence as this: an incident consisting of a riot, a brawl, or a disturbance in which bodily injuries are sustained by any person, and such injuries would be obvious to a reasonable person, or tumultuous conduct of sufficient intensity as to require the intervention of a peace officer to restore normal order, or an incident in which a weapon is being brandished, displayed, or used. If an act of violence occurs in the premises or near the premises, such as the parking lot, the event must be reported to the DLLC or other law enforcement within 7 days of the act. Failure to do so could lead to criminal charges to you and additional legal ramifications to the owner, licensee of the establishment. You can find the required document to submit on the DLLC's website. It is very important that your establishment works to maintain a safe environment. By having sufficient lighting for the parking lot and areas where alcohol is served and or sold can lead to more security for employees and customers. If a licensed premise, off-sale or on-sale, has repeated acts of violence, their license could be in jeopardy of being suspended or not being able to renew. The DLLC definition of repeated acts of violence is this: for licensed premises with a permanent occupancy of 200 or fewer persons, 2 or more acts of violence occurring within 7 days, or 3 or more acts of violence occurring within 30 days. For licensed premises with a permanent occupancy of more than 200 but not more than 400 persons, 4 or more acts of violence within 30 days. For licensed premises with a permanent occupancy of more than 400 but not more than 650 persons, 5 or more acts of violence within 30 days. For licensed premises with a permanent occupancy of more than 650 but not more than 1,050 persons, 6 or more acts of violence within 30 days. For licensed premises with a permanent occupancy of more than 1,050 persons, 7 or more acts of violence within 30 days. For the purposes of the above, the permanent occupancy means the maximum occupancy of the building or facility as set by the fire marshal for the jurisdiction in which the building or facility is located. The DLLC takes public safety very seriously. That is why they suggest that establishments have security procedures in place. A security procedure should entail the following: monitoring admission of guests, interaction with guests, when to call for law enforcement, strategies for use of force and de-escalation techniques. The front door can be the first line of defense. As guests enter the establishment, look for signs of intoxication, bad attitudes, etc. If they are intoxicated, they cannot enter the establishment. The law is on your side. If they have an aggressive behavior, talk to them to find out where they are at. If you can tell the person is looking for a fight, don't allow them in. If the person or persons become aggressive while they are in the establishment, do your best to defuse the situation. Don't come across as being threatening. Nonverbal communication makes up 90% of all communications. Keep your own emotions under control. Your emotions are the only thing you have complete control of. Listen to them.
Try to find common ground that you can use to get the disruptor to calm down. Talk to their friends. A lot of times, the friend will defuse the situation. Arizona law allows you to use force when justified. Helping a police officer allows you to assist a peace officer in the performance of their duties. Order maintenance allows a person responsible for maintenance of order, you, to use reasonable force to the extent that a reasonable person would believe it necessary. Self-defense allows a person to threaten or use physical force when physical force is necessary to protect himself against unlawful force. Verbal provocation is not justified. There is no criminal charge of verbal assault. Verbal provocation is not a justification to assault. Acting as a security guard in an establishment and getting into a physical altercation that is not deemed reasonable can have consequences such as criminal liability. You may be charged criminally. Civil liability. You may be the subject of a lawsuit. Employment. You may lose your job. Compensation, security, or it may impact future employment. If an establishment uses a registered security guard, the establishment must attempt to verify the validity and status of the security guard's registration certificate. There's a form on the DLLC website. The form shall require the applicant or other persons to disclose whether in the previous 5 years the person has been a registered sex offender or pled guilty, pled no contest, or been convicted of any offense that constitutes assault, homicide, domestic violence, sexual misconduct, misconduct involving a deadly weapon, or a drug violation that constitutes the illegal sale, manufacturing, cultivation, or transportation for sale of marijuana, a dangerous drug, or narcotic drug. A licensee may not hire or assign to a role as security personnel any person who fails to complete the form or if the form discloses one of the listed offenses within the previous 5 years. The licensee shall maintain on file affidavits of all security personnel hired or designated by the licensee. The form may not be required for a peace officer who is certified by the Arizona Peace Officer Standards and Training Board or other security personnel who hold a current security guard registration certificate or armed security guard registration certificate issued pursuant to Title 32, Chapter 26.
It is illegal to sell or serve alcohol to someone who is obviously intoxicated. It is also illegal to serve someone to the point of intoxication. The definition of obviously intoxicated is this: inebriated to the extent that a person's physical faculties are substantially impaired and that impairment is shown by significantly uncoordinated physical action or significant physical dysfunction that would have been obvious to a reasonable person. The customer has to leave the premises within 30 minutes from when the intoxication was noticed or should have been noticed. The 30 minutes allows enough time for an unintoxicated person to arrive and take the intoxicated person away from the premises. Arizona Liquor Law, ARS 4-244, Unlawful Acts. It is unlawful for a licensee or employee to knowingly permit unlawful gambling on the premises. Arizona liquor law does not allow gambling at liquor license businesses when the customer is required to pay for a chance to win something of value. Amusement gaming, which includes all of the criteria stated in ARS 13-3301, 1A through D, requires that no cover charge or involvement by a licensed location or staff of licensed locations is permissible, and the game must be a game of skill. For example, a football pool can be played by customers of a licensed location if there is no cover charge to get in, and the staff of the location have no involvement in the pool. Another example would be a pool game which can be played and bets placed between the players. No side bets can be placed, nor can a cover charge be required by the licensed location. Food service. Food service is required for all Series 12 licenses up to 10 p.m., but the establishment has to maintain 40% of its revenue in food sales and 60% in alcohol sales. It must be a full menu. After 10 p.m., they do not have to serve food, but any person under 21 has to leave unless they are accompanied by a parent, legal guardian, or spouse who are of age. This concludes Module 4. Let's do a little recap. In this module, you learned about disturbances and illegal activities, lewd and disorderly conduct, gambling, and food service. You may now take the Module 4 quiz.